Thank you, Shania. Good afternoon, everyone. My name is Devin, and I'll be providing this presentation on court-ordered benefits. A little bit about myself. I was born and raised in the Midwest. I joined the military shortly after high school. I did serve during 9/11. When I got out of the military, I went and moved to Chicago. I got my bachelor's degree there at the University of Illinois at Chicago. I went on from there and got my law degree at John Marshall School of Law. I did practice briefly in criminal law and in civil law, but I truly found my calling here in the federal government, in particular in retirement services. Before we begin, a little bit of housekeeping. Right now, everyone is muted. I would prefer that everyone stay that way. So if you can, please mute your microphones. I'll attempt to stop periodically to respond to questions. Please put your questions in the chat room. If I'm unable to do that, then we will respond to the questions at the end of the presentation. But we're going to try answering them during the presentation if I can. But if you could, please put your questions in the chat. I think that will make things go a little bit easier. So like I said, this is a court-ordered benefits presentation, and here we go. So court-ordered benefits affects annuities and employees and annuitants and employees, both FERS benefits, CSRS benefits. It also has an effect on benefits, in particular for the former spouse's FEHB benefits. The FEGLI is affected by court orders. And we will also be discussing how court orders relate to the FEDVIP, the FLTCP, and the FA. Back in 1992, the Congress passed a set of new regulations, which OPM published. Those regulations are the Code of Federal Regulations, Part 838. Those regulations are what OPM follows when administering court orders that affect annuities. Regulations can be found in the Handbook for Attorneys, which is also published shortly thereafter, and which we will discuss a little bit more later. It's important to note that OPM's role is ministerial. We do not write the court orders, and other than interpreting them via the regulations, we do not interpret state law and how we apply court orders. Role of mediator belongs to the state courts. Basically, that means that any issues that the parties have, they must settle amongst themselves via the court. So a court order can do many things. It can divide CSRS and FERS benefits. It can divide refunds of CSRS and FERS contributions. And it can provide it's payable after the death of the employee or the retiree. It can also permit former spouses to continue their FEHB coverage. It can require an employee to cover his or her children under FEHB, and it can require employees to assign life insurance to his or her spouse, former spouse, or children. Finally, we do apply garnishments to annuities if we receive an applicable IWO. An IWO, income withholding order, is necessary for us to process a garnishment. Garnishments can be administered for a number of reasons, particularly 4 reasons. Those reasons are alimony, child support, in cases of previous child abuse, and for Chapter 13 bankruptcies. There are certain things that court orders cannot do. A court order cannot make a former spouse of an employee or annuitant eligible for FEDVIP. It cannot force an employee or retiree to cover his or her children under FEDVIP. And it will not make a former spouse qualified to receive federal long-term health care. What is a court order acceptable for processing? Essentially, a court order acceptable for processing, or a co-op, means that it is a court order that meets our regulatory requirements that affect an annuity, a refund of contributions, or awards a survivor benefit. There are requirements for a court order to be considered a court order that is acceptable for processing. It must specify that it is referring to either a CSRS or FERS benefit or a federal retirement, or refer to the employee as having worked at a federal agency. It must specify that. It must expressly state that the former spouse is entitled to a portion of that annuity. We prefer that the order direct OPM to pay, but it can be silent with regard to the payer. But again, it must directly state that the former spouse is entitled to a portion of federal annuity. The order must provide sufficient instructions for us to be able to compute the amount of the benefit. Providing sufficient instructions means that we do not have to look other than at the court order or at our case files in order to divide the annuity and provide the former spouse his or her portion. So any court order that instructs us to look at a state law to determine what the formula should be is not acceptable for processing. We will deny that order and return it and instruct them to provide us with an actual formula. There are 3 types of annuity. There's the net, the gross, or the self-only. I'll describe all 3 here briefly. The self-only annuity is the annuity that is paid to the annuitant before any deductions are made, including a reduction for survivor costs. The gross annuity is the self-only, but minus the survivor costs. So the gross annuity is ultimately what the annuitant will be paid. And then the net annuity is what the annuitant actually has land in their bank account after all the other deductions are made. Deductions for taxes, for health and life insurance, for allotments, and for apportionments, not including the former spouse in question. The court order can also just provide us a set amount. The order could simply state the former spouse will receive $500 a month. That is an order that is acceptable for processing. There are more requirements that are needed in order to consider a court order that is acceptable for processing. It must express. Okay, this is with regard to the survivor benefit. In order to award a survivor benefit, it again must refer to the fact that it is either CSRS, FERS, or some form of federal annuity. It must state that the former spouse is entitled to a survivor annuity. Now, this is separate from the apportionment. The survivor benefit must be indicated on its own. So simply awarding someone 50% of the gross annuity does not mean they receive 50% of the survivor benefit. They need to specify that they also receive a survivor benefit. The order can give the former spouse the option to elect a survivor annuity. If the order states something like that, then additional steps will have to be taken. The former spouse will have to write to OPM and either accept or decline the survivor benefit. Finally, the co-op must provide instructions, just like in the apportionment, that allow us to be able to compute the amount of the survivor annuity. This last bullet point is extremely important. The order must be issued either prior to the date of retirement or death, or be the first order dividing marital property after retirement benefits have commenced. So prior to retirement or death of the employee, OPM will accept as many orders as the parties wish to provide us, and we will apply the most recent order that we receive prior to the date of retirement, that is filed with the court prior to the date of retirement. Upon retirement, the only order that we will receive is the first order dividing marital property. So if the person retires in 2015 and they get divorced in 2017, whatever the first order that divides their marital property that is filed with the court, that is the only order that we can look at. This is with regard to survivor benefits only. We will always accept amended court orders for apportionment purposes. But for survivor benefits, only the first order after retirement or any order that we receive, the latest order we receive prior to retirement. There is a form called a QDRO, a quadro, which is a qualified domestic relations order that is often used to divide private sector retirements. Generally, we do not accept those quadros with one limited exception. The reason for that is private retirements follow a different kind of law. They're governed by the Employee Retirement Income Security Act, ERISA. CSRS and FERS retirements, federal retirements, are exempt from ERISA. We specifically follow 5 CFR 838. We wish to ensure that the orders that are submitted to OPM are filed with the understanding that they are familiar with the rules that we apply. When someone submits a quadro, there's a chance that they are filing it with the understanding that they are following ERISA law. This is incorrect, and this is not going to be an acceptable order for processing. There is one limited circumstance, and that is if the quadro specifically states that it is following 5 CFR Section 8 and is abiding by rules and terminologies that are used in that section. If the quadro contains that language, then we will find it acceptable. The rules affecting FEHB and FEGLI are governed by separate titles in 5 CFR. As you can see, they're listed here, Part 890 and Part 870. We will use those when we're administering or applying court orders to a federal employees or retirees annuity. This is a list of the rules and regulations that OPM Retirement Services will use to apply court orders to FERS, CSRS, FEHB, FEGLI, and to garnishments. I'm not going to read them all out. This presentation will be available to people after I'm finished. But as you can see, there are about 15 different rules and regulations that we are required to follow. An easy place to find these rules and regulations is in the Handbook for Attorneys on Court Order Retirement, Health Benefits, and Life Insurance. The Attorney's Handbook is what we recommend all parties, whether it be attorneys, employees, or former spouses, we encourage them to review this handbook in order to write a court order that we will find acceptable for processing. This handbook not only contains the rules and regulations that we follow, it also contains model language that we recommend court orders contain. So I would definitely recommend that you instruct your employees, if there is a divorce or will be a divorce on record, to review RI 38-116. Review that prior to writing a court order that will be submitted to OPM for processing. That website does direct you to where the employee handbook can be found on OPM's website. Now, there are some types of retirements that we do not administer. The two types that we get the most questions about are the thrift savings plan and the military retirement. The TSP is administered by the Thrift Investment Board, not by OPM. A separate court order for the TSP will be needed and provided to the Thrift Investment Board to divide the TSP. Likewise, we do not administer military retirement. The agency that administers military retirement is the Defense Financial Accounting Service. DFAS will be the group or agency responsible for administering military retirement. Their phone number is listed there at the bottom. The chat room to see if there are any questions thus far. So the first question that was presented is, who is the default payer if the court order is silent on this? This is referring back to when I recommended that the court order indicate that the annuitant be the one that pays or that OPM is the one that pays the former spouse. The default payer, if the court order is silent, it still will be OPM. We will pay the former spouse a portion of the annuitant's retirement. So in that respect, the annuitant is the one paying, we're the one administering it. But when the order is written, the order must either specify that OPM pay or be silent. If it's silent, it's understood that OPM will be the one administering it. Is there a time frame for a former spouse to elect a survivor annuity? There is. It is 2 years. 2 years from the date of divorce. That's right. 2 years from the date of divorce. That is how long that the former spouse has to elect their survivor benefit. Does this limit in retirement apply to amendments on the existing order as well? I might need a little bit more information on that question. I'm sorry. Are we referring to, Ms. Hurd, if you could provide me a little bit more information on that question, I'd appreciate it. I'm going to move on. How long does it take OPM to respond to a court order? Does OPM acknowledge receipt of the court order? The length of time it takes OPM to respond to a court order depends on a variety of factors. The difficulty in processing the retirement, difficulty in processing the court order, whether or not the individual has provided all the information that is necessary, whether or not they're retiring on disability. An average court or retirement file that contains a divorce, that has a divorce on record, takes currently approximately 6 months to process beginning to end, from date of retirement to full completion. Does OPM acknowledge receipt of the court orders? Yes, we do. Whether or if we receive them prior to retirement, the individual, whether it be the attorney or the former spouse that submitted the court order, will receive a letter indicating whether we approved or denied the award. And that will also be explained a little bit later. Can you repeat the statement again that the quadro must have in order for OPM to accept the document? That information can actually be found in 838.302. I will attempt, but ultimately the order must state that the parties and the court recognize that the rules and regulations that are being applied in the court order adhere to Title V, Section 838, and that it is abiding by the terminology and conventions used within that regulation. That language is required for a quadro to be acceptable. Again, that language can be found more specific language can be found in the handbook. And I do believe it is under 8.302. Question. Right before retirement and submits the divorce decree with the retirement application, how long can an employee expect to remain in an interim status? How much can the employee expect to receive while in interim pay? The first question I answered, average length of time for processing a retirement file with a court order is usually about 6 months. It can be more or less depending on, again, the difficulty in processing, whether we have all the documents that we need, whether or not it is a disability retirement. How much can the employee expect to receive while in interim pay? That is a question I cannot answer. I do not set the interim pay. That is done by our pending retirement branch. And they use a formula that I'm not familiar with. So the interim pay can be anything from 0 up to 50% of what is expected to be their final pay. They will pay less in interim pay if there's a court order on record, because they will not have any idea how much the former spouse is set to receive. But I cannot tell you exactly how much, because I'm not familiar with the formulas or what amount that they use in order to provide their interim pay. That is a question that we will write down, and we'll see if somebody can provide a little bit more information about that after the presentation. If the employee is retiring but the divorce is not finalized, what do they mark on their retirement application? Well, if the divorce isn't finalized, then by law they're still married. And so they would have to follow the requirements set forth in the application for a retiring employee who is married. This becomes extremely important for survivor benefits, because they will have to either approve or deny the survivor election on their application. And if they're denying their current spouse, which the former, if they haven't divorced yet, it is still a current spouse, will have to sign off on not getting a survivor. So if the divorce has not been finalized and there's no legal separation involved, then technically they are still married and they have to fill out their application as though they're still married. Is there a way that we can find out if an employee submitted their divorce decree to OPM? You can contact OPM. Our general phone number is 0222. I will also be providing my phone number at the end of this presentation. If you wish to have a direct point of contact, you may use me. I expect I'll be getting flooded with notifications, but that's perfectly okay. For employees who elected to retain NAF coverage, would their employees contact DFAST for court-ordered info? If NAF coverage is relating to the military, then I will say yes. But I do not know what the acronym NAF stands for, so that will hopefully I answered that question correctly, because I know we do not administer anything called NAF, so that is not under OPM's purview. Does the limit on only accepting the first court order in retirement apply to any amendments on that specific order? So again, hopefully I'm being clear, but the limit on only accepting the first court order only applies to the survivor benefit. And it's only the first court order after retirement. So if the parties divorced in 2010 and the retirement happened in 2020, there can be amendments, 5 amendments between 2010 and 2020, from between the time of divorce and the time of retirement, that involve the survivor benefit. And we would accept the most recent order prior to retirement. The first order rule only applies when the divorce happens or either concurrently with retirement or after retirement. That is when we will need, we can only apply the first order that divides marital property. So there can be amendments on court orders as long as they all are, with regard to survivor benefits, as long as they are all received prior to retirement. And then we'll apply the most recent one. If another order is received, so in that example, if the individual divorced in 2010 and retired in 2020, and 5 court orders were submitted between 2010 and 2020 involving the survivor benefit, and we received another one in 2021, we would not accept the 2021 amended order with regard to survivor benefits. We would apply the one we received, the latest one we received before retirement. Now, this does not apply to the apportionment. We will always accept an acceptable court order for apportionment purposes and for survivor cost purposes. But we cannot amend the amount of the survivor benefit except in the first order that's received after retirement or the latest order that's received prior to retirement. If the language defines the marital portion value of the former spouse survivor annuity shall be determined by multiplying the former spouse survivor annuity by a fraction, the numerator, which is married during service, the denominator is total service. Does this meet specific instructions language? Yes, it does. There are three common types of survivor awards that we administer. One is max survivor, one is no survivor, or there's four, I guess. One is half survivor, and then the other one is what's called a pro rata share. The pro rata share of a survivor is total months of service during marriage divided by total months of service. And take that fraction and multiply it by the max survivor, and that is the amount of the survivor that is awarded. So yes, that language, that language that was presented in this question is acceptable for the formula. There is a legal separation. How is the paperwork completed? No, with the answer, no, you are still married. No. We do process legal separations the same as we do divorces. And the final question, is the FERS supplement included in the payment if it is awarded? The answer to that is yes. If the FERS supplement, if the order is silent regarding the FERS supplement, then it will automatically be included. If the order specifically includes the FERS supplement, it will automatically be included. If the court order specifically states that the FERS supplement is not to be included, then it will not be included. But it must state that specifically and unequivocally. Thank you very much for your questions. I will now be continuing on with the next part of the presentation. What can a court order require from an annuity? Basically, all this means is what benefits are available via court order. The first type of benefit is an apportionment. An apportionment is a percentage or a set amount or a portion of an annuity that can be paid out to a former spouse, or if the former spouse passes, to the former spouse's, to the party's children and or her estate, his or her estate, former spouse's estate. But those payments will only be paid out during the retiree's lifetime. So when the retiree dies, apportionment payments stop. If there was a survivor benefit awarded, then the survivor benefit will pick up after the retiree's death. We can also pay out a refund of contributions. So as you know, all employees contribute to their federal retirement. The court order could also state that the former spouse is due a portion. Again, you had to have to provide the formula or the amount of whatever the annuitant has contributed to his retirement, his or her retirement. We will accept court orders that provide for refunds of contributions. Court orders will also commonly require that OPM not pay out refunds to retirees. This prevents retirees from collecting on what they've contributed as in lieu of a retirement. Court orders do this in order to ensure that there is a retirement benefit available to the former spouse. As I indicated before, the former spouse can be either a fixed amount, it can be a percentage or a fraction, or it can also be a formula whose value we can determine from the order and from our case files. But the formula itself must be ascertainable. If we have to look outside of the court order or our case files, it will not be acceptable. So again, do not instruct OPM to refer to a state's law in order to divide the benefit. That will not be acceptable. The order itself, the final amount to be paid to the former spouse cannot exceed the annuitant's net. So if, for example, the court order states that the former spouse is to receive $2,000 a month, but the annuitant only receives $1,000 a month, that's not an order that we can pay out. That's not an order we can accept because the requested payment amount exceeds what the annuitant, what the retiree is receiving. Court orders can also terminate benefits. The most common way that court orders will terminate benefits is if we were to receive an amended order that terminates the apportionment in an existing order. And that applies to either a former spouse, the former spouse's estate, former spouse's children. We will always accept court orders that amend previous orders for apportionment purposes. So if an annuitant feels that his or her former spouse has been paid enough, they are always welcome to return to court and request a termination order that stops the former spouse's apportionment. There is another limited circumstance, and this is only found in set amount cases where the order itself indicates that the former spouse is only to receive that set amount for a certain number of months. That is also, that's an order that self-terminates. We can process that as well. Regarding survivor benefits, again, we will accept amended orders for survivor benefits if that amended order is received prior to retirement. We will not accept any order affecting survivor benefits if that order is received after retirement. So there are some ways that survivor benefits can be provided for a former spouse. Most common, the type that we deal with most in court order benefits is via court order. And a court order can award a survivor benefit for a former spouse. it cannot provide a survivor benefit for a child or an estate. The survivor benefit is only for either a current spouse, which we're not dealing with here today, or a former spouse. The annuitant, the retiree, can also elect a survivor benefit during his retirement in his retirement application while he's retiring. If the employee, who's still currently an employee, is currently married to someone else, then the only way that he can allow for a survivor benefit for his former spouse is if the current spouse consents to it. So that is something that they would have to work out. But if the current spouse does consent, or if there is no current spouse, an employee who's going through the process of retirement can elect a survivor benefit for a former spouse. Now, there's some requirements that have to be met in order for that to take place. The marriage has to have lasted at least 9 months before the survivor election can happen. And if the former spouse remarries before the age of 55 and they were not married for at least 30 years, then the survivor benefit terminates automatically. And that is by law, and the laws listed are below. If the parties were married for 30 years prior to a age 55 remarriage, then that law does not have effect. That the law makes an exception for that. Now, if the employee, so this is prior to retirement, if the employee dies, there is a survivor benefit that is payable to the former spouse if the employee had worked at least 18 months in federal service, non-military federal service. And under FERS, under both CSRS and FERS, there is a survivor benefit. Under FERS, there's also a basic employee death benefit. That's only applicable if the employee has worked for at least 10 years of credible service. So under CSRS, there is a requirement that for the former spouse's survivor annuity to be payable, he has to have filed an application not died after age of 62. All right, I'm sorry, I read that wrong. There is no former spouse survivor annuity payable unless the employee died after age 62 and an application for retirement benefits has been filed. Under FERS, there is a survivor annuity payable if the annuitant has title to a deferred annuity. The basic employee death benefit is also payable unless the court order excludes it. So for CSRS and FERS, the maximum amount of the survivor annuity available is different. Under CSRS, the maximum survivor benefit allowable is 55% of the self-only unreduced annuity. So, for example, if the self-only annuity is 55%, is a hard number to calculate on the fly. $10,000 a month. The maximum survivor annuity available will be $5,500. That's 55% of $10,000. With all survivor benefits, there is a cost involved, and that cost reduces the gross depending upon how much the survivor benefit is. So at 55%, that's 10%. If the employee retired and was making $10,000 a month, then that $5,500 survivor benefit will cost $1,000, 10% of the $10,000, which means that their gross will then be $9,000. That is what they will get paid. Another thing to keep in mind, awarding a survivor annuity to a former spouse reduces the amount that a current spouse can receive. I will cover this a little bit later, but this involves order of precedence. Who receives the amount or the award first? And court orders will always take precedence over elections. For FERS, the maximum is slightly less than for CSRS. So for FERS, the maximum amount is 50% instead of 55%. Same rule applies regarding the amount that a current spouse can receive if a former spouse has received an award. So if a former spouse is awarded the max via court order, you can still elect a survivor benefit for your current spouse. It's what we will call an unfulfilled election. That election will have no value if you die prior to your former spouse. So if the annuitant dies, then the former spouse will begin receiving the survivor benefit. But if the former spouse passes prior to the annuitant, then that election, so the court order will basically go away because the former spouse is no longer alive. And then the election for the current spouse will take effect. So if the former spouse was awarded the max, the only way a current spouse can receive anything after the annuitant dies, former spouse has to die first. There is another example where if the former spouse was awarded half, I'll just use half as an example, anything less than the max. So we'll stick with half for right now. If a former spouse is awarded half and the current spouse was elected the max, the former spouse can receive, and then the annuitant dies, the former spouse would receive her half first, and then the current spouse would receive whatever's left, up to whatever their election was. So if the former spouse was elected half, or was awarded half via court order, and the current spouse was only awarded 25% via election, then the former spouse would get her or his half, and then the current spouse would get their 25%. So in order of precedence, the former spouse receives their full amount first, and then whatever's left up to whatever was elected for the current spouse, that's what the current spouse will receive. Some annuitants would like to make sure that their current spouse receives a survivor benefit even if the former spouse is awarded the maximum via court order. The employee can elect to give or to provide an insurable interest survivor to the current spouse, or even a former spouse if they wish to provide additional benefits. There are health requirements that have to be met, and disability retirees cannot elect a survivor or an insurable interest. I will notify you that, or you should notify your employees that there is a higher cost to provide an insurable interest. The cost is, I want to say, almost double what the regular survivor cost is. So as long as the retiree is aware of that, they are welcome to make an insurable interest survivor election. This goes back to the ability to alter or change survivor benefits after retirement. Court orders can change survivor benefits prior to retirement, but they cannot affect benefits after retirement. The only exception, once again, is if the divorce happened after retirement, then we're not accepting any amended orders, only the first order that divides marital property. I realize that I continue with this survivor benefits explanation, but I want to make sure that it is fully understood. Are there any questions at this point? So the first question is, in the example of the court order stating, okay, so this was one of the examples I provided, stating the former spouse is awarded $2K and the annuitant only receives a net amount of $1K, what happens? You answered the question. OPM will pay the former spouse $1K and the annuitant receives $0. So the way we'll process that is we will provide as much of the payment as possible to the former spouse and include in our announcement, our letter to the parties, that this is the reason that the former spouse is only receiving this amount. And this is the reason why the annuitant is receiving $0. If the court order, and question, court order requires amount to be paid exceeds the annuitant's net, does nothing get paid? The annuitant will receive $0. The former spouse will receive up to as much as can be provided. And actually, let me get back to you on that, just to verify that that is how we apply our court orders. So before I get too far off the reservation here, let me double check that. Do the former spouse's apportionment self-terminate if OPM is informed that the former spouse is deceased? Yes and no. So first, we do have to be notified in order that the former spouse has deceased prior to any action being taken an end to the former spouse's payments. End of the former spouse's payments does not automatically put an end to the withholdings from the annuitant. The reason for that is we need to review the court order to verify if something goes to the estate or the party's children. So we will continue to withhold from the annuitant until we can make that verification, and then if a refund is due, we will pay it at that time. If we're never informed that the former spouse has passed away, then his or her bank account will continue to receive the money, and then we're going to have to get it back. Because upon death, that money should not be getting paid to that account anymore. If a retired employee has a court order that pays for former spouse, then remarries while retired, what can the annuitant do for the current spouse? After the retiree remarries, I'm presuming this is with regard to the survivor benefit. the annuitant can elect a survivor benefit for the current spouse. Again, that current spouse will not be first in order of precedence because court orders will always take precedent over elections. But the annuitant does have a period of time, a time frame, again, 2 years, to elect a survivor for the current spouse. What if a CSRS employee remarries ex-spouse and has a court order for the former spouse to receive a portion of the retirement? CSRS employee is retiring next month and wants to leave a survivor for now current spouse. Will OPM enforce existing court order? And the answer, well, the last question is yes. So even if, and this is a weird aspect of how we apply court orders in OPM remain valid until we receive another court order that invalidates it. So even if a CSRS employee remarries the former spouse, the court order that was involved during their divorce is still a valid order, and we will still apply it. In that case, the now current, well, the former spouse, but now current again, will continue to receive his or her portion of the CSRS retiree's annuity. Regarding and that's for the apportionment. Regarding the survivor benefit, the survivor benefit still holds as well. Again, it's an odd situation, but that court order, we cannot terminate it because it's after retirement. So the former spouse, who's now the current spouse, will receive a court-ordered survivor benefit. Again, that's a very odd situation. We don't see much of that. And wants to leap survivor annuity for now current spouse. I mean, if you're talking about okay, so the CSRS employee has not retired yet. If we will receive a court order terminating the survivor benefit for the former spouse, and we receive that prior to the employee's retirement, that terminates the court-awarded survivor benefit for the former spouse, we would apply that. Upon retirement, whatever was previously court-awarded is set. There's a very limited exception for that, and I'm not really sure exactly how the rule or how to explain it, except that if a court order is declared, there's certain legal terminology. It's declared null and void and without effect, as though it had never existed. That's not the precise language. I would recommend having the parties consult an attorney, but essentially it would negate the previous divorce. And again, I'm not really sure how that's possible, but there is very limited language that basically means that the divorce never existed. And please don't ask for further clarification on that, because I don't even know how that works exactly. Is the insurable interest treated as a separate supplement amount? It's considered a separate survivor benefit. Yes. If the annuitant dies and then later the former spouse dies, would the current widower then be able to receive benefits? No. Once a survivor benefit starts being paid out to the former spouse or to whomever receives it, once that person dies, the survivor benefit ends. The employee elected a survivor benefit that is not payable due to the court-ordered benefit for the ex-spouse. Will the surviving spouse be able to retain FEHB coverage, or will it be terminated? This is slightly outside of court-ordered benefits purview, but it is my understanding that the current spouse of a retiree can continue to maintain their FEHB coverage because they're still considered a family member. We will provide a little bit more clarification for that question after the presentation. How long prior to retirement do you recommend that an employee submit a divorce decree to OPM? This is actually covered at the end of my presentation, but I would recommend that all divorce paperwork, the divorce decree, settlement agreement, any orders that divide FERS, CSRS, any order that will affect their retirement, I recommend that they provide them to OPM as soon as practical. If they're not planning on retiring for 10 years, we can get the documents now and make a determination that will speed things up at the time of retirement. So my recommendation is to submit them immediately after divorce. I also recommend that another full set of the documents be submitted with your agency's paperwork at the time of retirement. That way we will have already seen them and made a determination, and you can provide a second copy with your retirement papers to ensure that we have all the documents that we need. We should, but sometimes filing errors happen. That's a good question. Responses that are provided to the inquiries in the chat, will they be made available other than just in a verbal format? Yes, hopefully we will be able to provide written responses to what I'm saying verbally. As the only presenter, I'm not able to both respond via chat as well as go through my presentation. And that's the conclusion of that set of questions. So now we can continue with presentation. There are requirements that must be met for us to accept an application for benefits. First, the former spouse or his or her representative must apply in writing to be eligible for the award. The application must be accompanied by, and this is where I was saying it would be good to have the documents already on file with OPM, because if there are no orders available, then the application must be accompanied by a court-certified copy of the order. And this is order, it's really orders plural. It's the divorce decree is always required, signed and certified. We also require certified copies of with the rate seal of all the orders that divide federal benefits. So divide FERS or FERS, or provides just a survivor. We will always need certified copies of both of those documents. With regard to the application, there's no special form that's required. There is a special form that we are working on there is a form we're working on right now that we are recommending individuals use, and that will be on the OPM's website once it's completed. But ultimately, I inform customers that as long as you submit in writing that you are supposed to be awarded a portion of a federal retirement and you'd like to receive that award and provide us with enough identifying information, that's acceptable. So the identifying information can be, if you have a CSA number, that's acceptable. A Social Security number is certainly acceptable. We just need the requesting party, so the applying party needs to be able to identify themselves so that we can associate that individual with the retirement case file. And we will accept applications from either representatives or former spouses attorneys. So if there is an issue of competence, the representative can apply in their stead. And just as I explained, the letter must request payment from the retirement benefit, and the other documents that are part of the court action, we will need those. So if they haven't been previously provided, the applicant will need to provide them at the time of their application. The applicant must also certify that the order that is there is a court order currently in force and that has not been amended, superseded, or set aside. This is also a requirement for applying for federal benefits after federal retirement benefits. And this goes back to providing sufficient identifying information. If they have the retirement claim number, the CSA number, provide that. Obviously, we'll need their full name. Social Security number is necessary if they do not have a CSA retirement claim number. Providing a date of birth is very useful information. We will also need the former spouse's current address. That is part of, in order for us to be able to communicate with the former spouse, we need to know where to mail their letters. The former spouse should also inform us that they have not remarried. That might seem like an odd thing, but that will affect a former spouse's ability to receive survivor benefits. So we need to know if that former spouse has remarried. That is the address, and I'll leave this up for a few minutes or a couple minutes so that you'll have time to write this down if you wish. This is the address where all court-ordered documents should be sent. The second address, it's a Boyer's address, but we prefer to have all court-ordered benefits documents sent to our DC address so that the Cobb branch in DC can process the court orders that we receive. All right. And now I'll check to see if there are any questions for that short portion. So the question is the official original certified copy or a copy of, is this official original certified copy or a copy of the official certified copy? So we need, so when court orders are filed with the court, the parties will go through their court process, they'll get the judge to sign it, and then that document gets filed with the court. We don't require that exact copy because it needs to be filed with the court. But once it's filed with the court, then the parties can go to the court clerk and get what's known as a certified original. They make a copy of what's in their court records, and then they put a stamp on it with a raised seal certifying that this came directly from court records and that is an authentic and true copy of what is filed in the court. That is the document that we need. We will not accept a copy. So if you take that document that you got that has the raised seal from the court clerk, and then you scan it in or you email it, that becomes a copy. It no longer has the raised seal, and it's a photocopy. We do not accept photocopies. We need the actual document from the court clerk that has the court clerk's raised seal on it. Those are the documents that we need. So the next question is, there's no email box to receive these documents. Our current regulations require us to receive the original, the document that still has the raised seal on it. As long as we have that, or as long as that regulation remains in place, that is the way we have to process it. Does OPM send the former spouse a request to provide proof or certification that they have not remarried? In our letters, there is often something that refers to, provide us information on whether they or not a remarriage has occurred. That would be the request to provide certification that there has not been a remarriage. Does the OPM verify if the former spouse remarried, or you take them at their word? I presume that we would take them at their word. If it's requested, we can do some research into that, but at that point, it seems more likely that the former spouse, the annuitant, would have a better idea of whether a remarriage has taken place or not. Keep in mind that marriage certificates are public records. So if the annuitant truly believes that a remarriage has occurred, then it is incumbent upon the annuitant to verify if that remarriage has occurred. OPM is not going to expend the resources to do Google searches to find out if a former spouse has remarried or not. So I suppose my answer to your question there is yes, we take them at their word until we receive other verifying information otherwise. If the divorce decree doesn't award the former spouse any part of the annuity, it says FERS, but I'll assume either FERS or STIRS, or a survivor benefit, does the decree need to be sent to OPM for filing? Yes, it does. Even if there's nothing awarded, we still need to have those court documents sent to OPM so that we can verify that no award was granted. So yes, we will still need the divorce decree, even if nothing is awarded. If a former spouse of a not yet retired employee is currently covered under TCC, as the divorce was completed 2019, when can the former spouse expect to hear from OPM? Okay, hold on. That's a hefty question. If a former spouse of a not yet retired employee is currently covered under TCC, when can the former, as the divorce was completed 2019, when can the former spouse expect to hear from OPM for approval of the FEHB of continuous FEHB beyond their TCC? Okay, so their divorce was completed September of 2019. That question is going to depend entirely upon when the orders were submitted to OPM and if we received them and what determination was made regarding whether or not a benefit was awarded. So in order to continue with FEHB beyond TCC, there has to be a court-awarded benefit, either an apportionment or a survivor benefit. So once that approval is, or presuming that there is an award granted in the court orders with the divorce. Once we've made a determination, OPM will send a letter to the party, and that letter they can then take to the employing agency indicating that they are entitled to an award, and then their employing agency can set up their FEHB. We cannot set up their FEHB until after the retiree has or until after the employee has retired. So they would take that approval letter to their to the employing agency in order to process for an FEHB benefit. This one probably doesn't make a lot of sense to a lot of people, but the answer is still yes. The question is, if the divorce occurred before FERS employment, does a decree still need to be submitted? And the answer is yes, because the divorce will still be on record. And even though logically they're not going to be awarded part of something that had nothing to do with the marriage itself, we still need that divorce decree in order to verify it. Like I said, it's not really intuitive, but because we're aware that there's a divorce on record, we still need the divorce documents. That way we can verify that there's nothing been awarded. You were advised during the 2018 festival to never turn in a decree if the ex-spouse was not eligible to get a benefit. I don't know who told you that, but that is certainly... I will advise the exact opposite. Always turn in a decree if there is a divorce. Whether or not the former spouse is entitled to anything, we still need to review it. And that will slow down the retirement process if we're waiting for that court order that even though there's nothing awarded, we're still going to hold on to that, put a hold on that retirement until we get the court order to verify it. So yes, that was incorrect. The presenter that year was, if the court decree specifies a percentage, that just disappeared. Percentage award to the spouse, and the employee receives a letter stating a different percentage from OPM, what action should the employee take? There are a couple of things that the employee can do. They can reach out to OPM first. I recognize that a lot of people have complaints about our 606-0222 number, but that is still a good option to contact OPM. Find out why, you need to find out what specialist made that determination, which should be in the letter that is received. And that letter should also include their name and email address. So you should be able to reach out to the specialist that made that determination directly. If there's still a question regarding how it was processed, then if if it's within 30 days of the award letter, the letter that's received, you can file for reconsideration. And I would reach out to whoever filled or whoever sent the letter and request reconsideration. Those are the first two steps that I would recommend. Should the decree or the employee former spouse's interpretation of the decree vary from what the specialist who made the determination, if their looks on it, their opinions on it are different, those are the first two steps I would take. I would recommend talking to the specialist first, because there are often times, so if a court order says, 50% of the marital portion, and the former spouse is thinking 50%. Well, 50% of the marital portion is a 50% pro rata share, not 50% of the whole thing. So maybe they just need to have that explained. I would recommend talking to the author of the approval letter first, and then if they still disagree, you can file for reconsideration rights. Question. So even if they mark that the ex-spouse is not eligible on the form, I'm assuming they mean the application for immediate retirement, you still need all the divorce decrees. Yes, we do. There have been more than a few applications for immediate retirement where the retiring employee put no, there's no former spouse entitled to anything, when in fact the former spouse was entitled to something. So instead of going after them for submitting a fraudulent application, we just demand to have the divorce decrees so we can review them. Yes, the application. Yep, that's what I thought. So yes, we will still need the divorce decrees. That's an excellent question. If the former spouse isn't entitled to anything, does it have to be a certified doc or can it be a copy? In that case, because there is no award, we will accept a photocopy. If the former spouse later wishes to argue that there's supposed to be an award, then the former spouse will have to provide a certified copy. But if there's no award, a photocopy will suffice. How should court orders be handled when the former spouse is a current Fed with their own FEHB and the former spouse is not awarded any benefits? Still supply, so one or both of the parties needs to provide us with the court orders so that we can get them into the system and make a determination stating that there's no benefits awarded to the former spouse in this case. I would, in that instance, definitely provide both Social Security numbers and indicate that both parties are or were federal employees, because we will need to set up in our records where the employee is a federal retiree and then where the former spouse is going to be a federal retiree. So we're going to have to set it up both ways, where they're both considered federal retirees and then the other party are both considered former spouses. So I would definitely make that clear in the documentation that is submitted to OPM. Because even though there's no benefits, we still need to put a record in a system stating that person A is a retiree and person B does not get any benefits. And then we need person B is going to be a federal retiree and person A does not get benefits. We need to keep track of it in that way. So absolutely, one or both parties needs to provide us with the complete divorce documentation. If the employee answers no to the question regarding a court order stating a portion of the retirement should go to the former spouse, is that why we would have been told the divorce order does not need to be submitted? When that question is answered no by the, otherwise how would we know a court order exists? I mean, it's possible that's the reasoning behind why you were told that. I don't know. I'm recommending something different than what you were previously told. My recommendation, immediately upon retirement, or obviously not the same hour, but within a short period of time after divorce, not retirement, divorce, submit court orders to OPM. I'm trying to be as clear about that as I can. We need the court orders when there is a divorce on record. And if they put no on their application for immediate retirement, I mean, that's fine, but we still need the court orders so that we can verify. Oh, yeah, it's not a 222 number. I'm sorry. It's the phone number that I was referring to for our customer service is area code 202-606-0222. That will also be provided in the chat responses when we have a chance to do that after the presentation is completed. If the divorce decree was previously submitted to OPM at the time of the divorce, should we send it again? I recommend yes. It's not required, but as I'd indicated before, sometimes something happens in filing where the divorce decree isn't associated with the retirement file. We still need to review it, which means we're going to be spending extra time looking for the one that was previously sent to OPM. Ideally, we'll eventually enter in all electronic format, so all these documents will be at the tips of our fingers. But until that happens, we need to put in a request to have a storage facility look for the documents that have already been submitted. So for convenience sake, I would recommend that an extra copy that it doesn't necessarily need to be a certified copy, because if we've already received previous certified copies, then all we need is the copies in the retirement file, just photocopies. I recommend including them. That way there's not additional time wasted looking for documents in order to get the retirement processed. You got to remember that these employees, they're still on interim pay. These recent retirees are still on interim pay until their retirement's finalized. So the quicker that can happen, the better for everyone. And there are some additional questions, but we got less than a half hour, and I've still got some I still got some more slides to go through here. So I'm going to keep going on here real quick, and we'll probably answer these questions at the end. So what is the role of OPM? Again, like I said before, OPM's role is ministerial. We accept the court orders as they're written. We make sure that they're acceptable, and then we apply them. We require clear, specific, and express instructions in these court orders. And if the order isn't acceptable, parties will have to return to court in order to make the changes needed in order to make sure that in order for it to become acceptable. Those changes can only be done in state court. So the former spouse, one of their requirements for a former spouse is filing a certified copy of the court order along with other supporting information. We interpret that to mean all the court orders that are involved with dividing FERS or CSRS benefits, as well as any settlement agreements that might include or mention them. The former spouse is required to maintain a current address with OPM. So if they change addresses, they need to update us. The former spouse or legal representative, I'm just going to go with former spouse, but they are required to tell us if anything has changed that would affect their ability to receive benefits. This is where it's important to notify us if they have remarried, because that can affect their ability to receive a survivor benefit. The parties are required to resolve any differences or arguments regarding interpretation of language with the state court. We will apply our regulations to the court orders that we have in hand that are acceptable. If that interpretation doesn't, abide by the intent of the parties, it's up to the parties to make the changes to the court order in court, and then provide us with an order that more closely mirrors their intent. We do not apply intent. We apply the words of the court order. So once we determine that an order is acceptable, there are a number of steps that we are required to make. And this goes back to one of the questions that was previously asked. We do have to inform the parties that the court order is acceptable. We have to inform them the date on which the benefits will begin. Now, if this is a pre-approval, then that date will simply be day after retirement. And that is their effective date. That's not when they'll actually start receiving the benefits, because we don't know when that will be. We can't provide an exact date, but we can say, their effective date will be the date of retirement. The letter will provide either the monthly benefit, if we know it, or a formula used to compute the benefit. In some cases, or in many cases, especially for recent retirees, we will provide both the formula used as well as what the monthly benefit will be. If the parties disagree, generally they're going to have to return to court in order to get a clarifying order. If one of the parties absolutely believes that we have misinterpreted or misapplied our regulations, they can file for reconsideration, which is another separate branch within OPM that will conduct a full review of determinations made by court-ordered benefits. If they wish to have their order reviewed by legal reconsideration, they need to submit a request for reconsideration within 30 days of the date of the letter that they're disputing. That's very important. The letter itself needs to be addressed to our legal reconsideration branch. That can become a lengthy process. And if the employee is a recent retiree and they're still in interim pay status, it can take legal reconsideration up to 6 months to make a determination. So I'm just going to leave that bit of caution with you. If they wish to go that route, they might be waiting a while. So if there is a dispute regarding the validity or the amount, generally you're going to submit a court order either invalidating or changing what the previous order said. In order for us to process the order that invalidated the previous order, we should receive it as quickly as possible. The longer it takes for us to receive it, the more months that the party will receive what they consider to be incorrect payments. Because our regulation, we apply, so court orders effective dates are the first day of the second month after we receive the acceptable order. So if there's payments that are being made or withheld and the order is received in October, its effective date is December 1st. So the longer you wait for us to receive it, the more will be made under that previous. And once we do receive it, we will review it, we'll make a determination, and the parties will be informed of any changes in their benefits. Garnishments overview. Garnishment is a process by which money can be paid out for alimony, child support, in cases of child abuse, and for Chapter 13 bankruptcy. And those are the only things that garnishments can be used for CSRS and FERS. The garnishment must conform to all state law requirements and is subject to the limitations of Title V, Section 5A1. Now, there are legal limits that are in place for garnishments. So we cannot withhold more than certain percentages of an employee, or I'm sorry, of a retiree's net. Those limitations are 50% or 55% if the retiree has remarried and has or has a child that they are supporting. And that's 50% of the disposable income, 55% if there is an arrearage. If there is no remarriage, those amounts increase to 60 and 65% respectively. So those are legally set limits on how much we can withhold via garnishment. So what is the disposable annuity? Well, it's the net. It is the annuity that is paid out to the annuitant after these five things have been deducted from the gross. So debts owed by the retiree to the U.S. government, we will withhold those, and that is going to be a deduction from the gross. HB, life insurance, Medicare, another court order, and federal state taxes. All of those things are deductions from the gross to give you the net. And the net is the disposable income that the garnishment orders can be applied to. That is the address where you can send garnishment orders. That is Cobb's primary address. I will give you a couple seconds. Moving on to FEHB. So FEHB is something that can be awarded via court order to a former spouse. This is important because once a divorce happens, the former spouse is no longer eligible to be covered under the employee or retiree because they're no longer considered a family member. They have to be removed. Former spouses that do not qualify for FEHB may apply for TCC. This is temporary continuation of coverage, and it is available for 36 months from the date of divorce. It cannot be extended beyond that. Former spouses can convert to a private carrier their policy from their FEHB. They can convert to a private carrier and continue their coverage that way. Again, the handbook provides information on where former spouses can look up FEHB information. And I would also recommend that they contact the employing agency's personnel office for additional information. FEDVIP, on the other hand, is not available via court order. It's not available to former spouses, and a court order cannot force an employee or a retiree to cover his or her children under FEDVIP. A court order cannot force that. And the Federal Employee Health Benefits Children's Equity Act, it only applies to FEHB. It does not apply to FEDVIP, the vision and dental and vision insurance program. Federal long-term care program, former spouses are not eligible for this. They're not considered a qualified relative, and they cannot apply for this. They aren't considered a qualified relative to apply or enroll, and a court order cannot make a former spouse eligible to apply or enroll. Now, I emphasized apply or enroll because if they are already covered, they can continue their coverage as long as they continue to pay the carrier through which they are receiving their federal long-term care. They cannot apply or enroll anew as a new covered person. But if they're already covered, they can continue their coverage. Court orders affecting FEGLI, Federal Employees Group Life Insurance. Now, if an employee assigns their life insurance, they no longer have control over the coverage itself or who the designated beneficiaries are. And assignments are irrevocable. So once made, they cannot be changed back. A court order can require assignment of benefits to a former spouse or children, but OPM can only process the form. OPM or the employing agency, we process the forms, but we cannot fill it out for the employee or retiree. They have to execute the forms themselves. I referred to this toward the beginning of my presentation. There is an order of precedence involved with regard to court orders. Now, I made that explanation with regard to survivor benefits. It also applies to FEGLI. On the FEGLI beneficiary form, when the employee or retiree fills out the form, they also put on that form the order of precedence in which people should get paid. Court orders supersede that. So if a court order instructs the employee to provide life insurance for his child, but instead had provided life insurance for his wife, the court order will take precedence over the election made. And that, so employees will file their FEGLI forms with their employing agency. Annuitants will file theirs with OPM. In either case, if there is a court order required, so if a court has ordered FEGLI to be granted or awarded to someone, we will need certified copies of the court order. If they've already previously been provided, then we have them on record and we do not need another set. But we do need at least one set of a certified copy of the court order. That is another reason why I have stressed that it is better to provide those documents to us as soon as possible, because it affects a lot of different things. So if an employee designates a beneficiary to receive his or her life insurance while they're still married, designates the wife or husband while they're still married, that designation does not end upon divorce. If the retiree or employee wishes to change the beneficiary, they have to file a form requesting that, the form on the previous page. They have to name a different beneficiary, otherwise whatever their previous designation was is still valid. And designations can be changed at any time unless a court order prevents it. And those are the forms that would be used to make a designation for life insurance and for lump sum. So what is the role of the employing agency? And this is going to be most of you. You are the providers of employment and pay information about service within your agency. During a divorce, if someone has questions about how much you've worked or what your pay is, OPM is not the agency to go to for that. The employee's own individual agent will provide that information, not OPM. We don't receive records until after an employee separates, unless there was previous employment at a different agency. In that case, we can be asked about existing previous contributions to the retirement fund for that previous service. But that's all the information we're going to have. So if the employee wants to know about what their current high 3 is, those are questions for the employing agency, not for OPM. The employing agency can respond to subpoenas issued regarding what the current retirement coverage is, what their current pay is. If a judge or other party has issued a subpoena, your agencies can respond to them. And you can provide annuity estimates using the service at least to that date. Agencies can prepare estimates of benefits that the employee has already earned. However, the agency cannot determine the proper division of benefits between spouses or the present value of the employee annuity. Private actuary would do that. Again, that will not be OPM. That will have to be done via a private party. Finally, agencies do not provide estimates that involve speculation or attempt to advise an employee, former spouse, attorney about how to draft a court order. I'm pretty sure you're familiar with that. OPM is the same way. We don't provide advice on how to draft court orders. That is up to the attorneys representing the employee and or the spouse or former spouse. Up until the date of retirement, all health insurance enrollments and life insurance assignments are handled by the agency, the employing agency. So you all will handle all health and life insurance related stuff while the employee is employed. If there is a divorce that has occurred, then the divorce paperwork will be sent to OPM, and we will make a determination and provide that letter to the parties should they wish to apply for health benefits, but that application will still be through the employing agency. It will not be through OPM. So how can agencies assist OPM? Do not have your employees fill out the voluntary election form or section of their retirement application unless they actually plan to voluntarily elect survivor benefit. Here's my advice that I've repeated a couple of times already, but it's worth repeating again. Provide complete court-certified divorce document to OPM immediately after divorce and again to the employing agency at the time of retirement. It's not mandatory, but that is my recommendation. And then finally, at least currently, notify your employees that they should expect retirement processing times to be approximately 6 months if a court order is involved. Retirement processing times are not 6 to 8 weeks. It's much longer than that, at least currently. We are exploring new ways to speed that process up, but at this time, we expect 6 months between date of retirement and finalization of a retirement file. This is how you can contact us. I've already provided you with one phone number. You can also contact our retirement information office at 888-767-6738. We do respond to emails. You can send emails to retire@opm.gov. We can be found on the internet. And my personal email, personal work email, is on the next slide if you wish to write that down. I thank you very much for your time and attention. I apologize for running over. If people wish to stick around and hear my responses to some of the rest of these questions, you're welcome to do that. Otherwise, the answers will be provided in written form after the presentation, probably sometime next week. Thank you very much for your time, and I hope you all have a great afternoon and a great weekend.